Good evening. I am pleased to present the Judge Barefoot Sanders Law Magnet Team 8. This is a respondents team. Uh, Avery Rose is here. Please say hi, Avery.
Hello, Your Honor.
And Ms. Brooke Sanchez. Ms. Sanchez,
Good evening, Your Honor.
are you both ready to proceed?
We are.
Yes.
The Supreme Court is now in session. We call the case of Torres versus Madrid. We will next hear from the respondent. You may begin.
Good evening, Your Honor. My name is Brooke Sanchez, and I, alongside my co-counsel Avery Rose, represent the respondents. Before continuing, would you like a brief statement of the facts?
No, that's not necessary. Thank you.
Now, the question presented before us is whether an unsuccessful attempt to detain a suspect by the use of physical force is a seizure within the meaning of the Fourth Amendment, or must that physical force be successful in detaining a suspect to constitute a seizure?
And Ms. Sanchez, what is your position? At what point does a police officer affect a seizure for purposes of the Fourth Amendment?
Your Honor, a police officer effects a seizure for the purposes of the Fourth Amendment at the very moment that they have successfully detained the suspect's freedom of movement or the suspect submits to the officer's authority.
Is that the common law definition? What is the common law definition of arrest?
Well, the common law definition of arrest is when an officer who uses physical force with the intent to restrain, whether it's unsuccessful or not, or if the officer submits or if the officer's suspect submits to their show of authority.
All right.
Now, before continuing, it's important to give context to the Fourth Amendment. For that, we must go back to Old England. English common law gave law enforcement broad discretion to investigate and take control of people and their possessions with general warrants. The English and Americans, by extension, were none too happy with this. The outrage and vitriol for general warrants weighed heavily on the minds of the founding fathers. When the time came to draft a Bill of Rights protecting the individual liberties of Americans, they made clear their intention to eliminate the practice, as can be seen in the New York Ratification Convention debates and in state constitutions long before that. The final product outlaws the use of general warrants while promoting the special warrant, which specifies the time, place, and manner by which a search and seizure can be conducted. Now, the first case that's most applicable to this case is Terry v. Ohio. For purposes of this case, Terry's most important contribution was its definition of a seizure, which is only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen, may we conclude that a seizure has occurred. In Broward v. County of Inyo, the court decided to affirm the definition provided in Terry and revise it to include intent requirement. Specifically, they said a violation of the Fourth Amendment requires an intentional acquisition of physical control. Broward's definition has served as a guiding star for Fourth Amendment seizure cases across the American legal system. And in today's case, the officers were unable to acquire physical control of the petitioner, meaning no seizure occurred to trigger the Fourth Amendment.
The petitioner seems to be relying on the common law definition, which Ms. Sanchez gave us a few moments ago, in the case of California versus Hodari. Did California versus Hodari hold that the Fourth Amendment encompassed the common law definition of arrest?
Well, yes, Your Honor, in regards to a submission to authority, but no in regards to the application of physical force. In the court of Hodari, it does seem to believe that the founding of the word seizure is encompassed with the common law definition of arrest. But if the court is familiar with footnote 2 in Hodari, it states that neither usage nor common law tradition makes an attempted seizure a seizure. And with that, we distinguish the circumstances in our case today with the common law arrest, seeing as the gunshots were an attempted seizure to stop Ms. Torres. An attempted seizure is not a seizure, Your Honor.
Well, why doesn't the language from Hodari apply in this case? If I recall, Scalia said, at least in some part, that there was an attempted seizure, could be an arrest. Why wouldn't that apply here?
Well, Your Honor, Hodari is a show of authority case. And the comments that Justice Scalia decides to make in regards to physical force are non-binding on this court. They're dicta. So any references to the application of physical force can be dispelled and can be set aside.
Now, a summary of our argument. The unsuccessful attempt to detain petitioner by using physical force does not constitute a seizure within the meaning of the Fourth Amendment. This court should see to the public meaning of a seizure. Throughout history, a seizure requires restraint of one's freedom of movement, as adopted in many case laws such as Terry, Brower, and Brenlin. Though officers Madrid and Williamson succeeded in hitting petitioner, they failed to stop her movement. She did not slow down or otherwise change her movements in any way. Petitioner's reliance on dicta from Hodari does not affect the determination of this Fourth Amendment question, nor does the reliance of English common law. American jurists' interpretation of the Constitution has diverged from common law principles to the point where it's only used as guidance. Finally, ruling in favor of the petitioner will set a precedent that overburdens the American legal system and unnecessarily and unproductively diminishes the quality of police work, damaging all of society.
Now, in regards to the first argument about cases involving seizures by physical force, particularly Brower, they contain the definition of seizure that controls this case. The dictionary definitions have long described seizures as taking possession of something. From Noah Webster's.
So I understand when you're, so you're going to go to the dictionary. I appreciate that. What was the original public meaning of the Fourth Amendment word seizure?
Well, this was the original public meaning, Your Honor. Noah Webster's original American dictionary said that it was the taking possession of something. The same applies to John Bouvier's Law Dictionary. And all the way up till now, with the 11th edition of the Merriam-Webster and Black's Law Dictionaries, all of these describe seizures as taking possession of something, an acquisition of physical control.
So how should that original public understanding, public meaning of the word Fourth Amendment seizure affect the analysis in this case?
Well, Your Honor, the respondents did not at any moment seize, take possession, or bring Ms. Torres into their custody or control. We should adopt this meaning of seizure because that is exactly what happened in today's case. It did not restrain her movements in any way. Now, in this case, the Fourth Amendment can only be triggered when there is a successful seizure. Common sense dictates that there can be no unreasonable seizure without a seizure in the first place. Now, as the plain meaning and Brower's meaning of seizure dictate, there was no seizure in this case. The respondents fired at the vehicle, striking petitioner, but failed to terminate her movements or even momentarily take physical control over her.
Ms. Sanchez, I'm not sure if I asked you or not. Was the police officer's shooting of Torres reasonable in this case?
Well, Your Honor, bringing forth this question would be asking the court to assume that Ms. Torres had been seized at the time of the shooting. We're here today to address if any seizure occurred at all. But if this case were to have a retrial, respondents would effectively argue that the shooting was in fact reasonable because Ms. Torres posed a danger to the police officers and to others around her who were on the road. Now, without the intentional seizure during the incident, there can be no Fourth Amendment violation.
Now, our second argument is about how the definition of seizure through the application of physical force in Hodari is not binding on this court. As I discussed earlier, Hodari was a case about a show of authority. Grappled with a novel issue, the majority opinion clarified the definition of a seizure by a show of authority, stating that an arrest requires submission to the assertion of authority. We do not contend that this definition is incorrect. We do, however, contend that the court's discussion about the definition of a seizure by use of physical force was irrelevant when deciding the case's outcome, making it non-binding dicta. Not alone. There are many lower courts who have also recognized this, from the 10th Circuit to the 3rd Circuit to New Mexico's federal district courts.
Mr. Rose, Ms. Sanchez, if we adopt the very limited version of seizure that you are suggesting to us, how are we going to be able to hold police accountable for shooting someone unreasonably, assuming the person gets away?
Well, Your
Ron-
Honor,
Sorry, go ahead.
we cannot adopt petitioner's expanded definition of a seizure because that would put a burden on the American legal system.
You mentioned that
The court-
before, Ms. Sanchez, but I'm not sure I understand your point. How would that burden the legal system?
Well, the courts have long held that seizures must be successful in detaining their suspects, ultimately restraining their freedom of movement. If this court were to expand on the definition of a seizure by including the mere touch or attempted seizures doctrine as petitioners suggest, it would create an immense load for the American legal system because they would be left to sort through the legion of new cases that would involve such acts, taxing an already overburdened system. This revised definition would weigh heavily on police officers unnecessarily. For example, if a police officer were to unsuccessfully grab at a suspect during a chase, tapping their shoulder would constitute a Fourth Amendment seizure under petitioner's new meaning. This level of scrutiny could hinder police officers' ability to act quickly for fear that they could be sued. In turn, this would interfere with an officer's ability to conduct good police work and protect our society. Effectively, the mere touch and attempted seizure doctrine would endanger not only the justice system, but also society as a whole. Finding in favor of the petitioner would put us all in harm's way. Now, common law does not control this court's understanding of a seizure for the purposes of the Fourth Amendment. The common law principles of an arrest that petitioner applies heavily bear no importance in deciding this case. Indeed, previous courts have looked to common law because of its informative discussions about issues brought forth in current courts. With that said, common law is certainly not dispositive. Now, a seizure and arrest are not synonymous. Despite petitioners' repeated assertions, the Fourth Amendment does not bar false arrests. It bars unreasonable seizures. Now, citing Terry v. Ohio, of course, just as not every encounter between a citizen and the police is a seizure, not every seizure is an arrest. Respectively, the definition of a seizure should not rest only on arrest, but with common sense, our common understanding, as discussed earlier. It is Brower's definition, unlike Hodari's dicta and common law definition, which comports with the common meaning of the word seizure.
Now, ultimately, an attempt to detain a suspect by the use of physical force must be successful to constitute a seizure within the meaning of the Fourth Amendment, as both plain definitions through the dictionary throughout American history and existing case laws such as Brower, Terry, and Brindlin have suggested. Furthermore, petitioners' heavy reliance on Hodari D and on common law arrest cases is misguided. Hodari D is dicta, and the common law has been set aside in favor of these Fourth Amendment cases, as I said, Brower, Terry, and Brindlin. Now, with that, Your Honor, we pray that you find in favor of the respondent and affirm the lower court's decision. Thank you.
Thank you. The case is submitted by the respondent. I appreciate it. Very good job, both.